Hi, Phil Silberman with the Silberman Law Firm here, and today we are going over the TREC 1 to 4 family residential contract. This is the most popular contract to use in the purchase and sale of residential real estate. So with that said, let's go ahead and figure out how to get this thing completed and go over all the blanks on here. First thing you want to look at is the date in the upper right-hand corner to make sure that you're using the most recent contract. As of the date of this video, this is the most recent one, and you can go to TREC's website to get the most recent versions. Parties to the contract, pretty self-explanatory. Fill in the seller, fill in the buyer. Then you get to the property description. This contract envisions a structure, a subdivided lot where you've got maybe lot 1, block 6, whatever of Harris County, Dallas County, and then you put the commonly known address here. Note that if you're dealing with a meets and bounds property, you may want to use a farm and ranch contract. If you have kind of a less common typical legal description, maybe a little longer, and it's meets and bounds, and you still want to use this contract, you really need to put something like see Exhibit A and attach an exhibit that has the meets and bounds description. And moving right along to the next blank, D, exclusions. This is where the seller puts things that they want to take with them. The default in real estate, if you're thinking about buying or selling a house, anything bolted down is automatically included as part of the improvement. So if the seller wants to take a chandelier, and that's obviously connected, bolted down, screwed into the ceiling, the seller needs to explicitly list the chandelier as an exclusion. Otherwise, the buyer is going to be entitled to the chandelier as part of the real estate price or the real estate transaction. All right, sales price. Put the cash portion here. So if it's $1 million property and you're going to put 10% down or 20% down, you put 200,000. Put your financing portion here. Most of it's going to be third-party financing is the most common one where you're just having a bank. So you'd have 800,000 for the third-party financing, maybe something like that, and then you would have your cash portion of 200 here, and then it would total for you to have $1 million total sales price. Paragraph 4, leases. This lets the seller disclose any types of leases associated with the property. You might have a tenant there, so it's residential lease. You may have a fixture lease. That could be the most common thing. There's maybe solar panels or a water softener that needs to be disclosed. Natural resources lease, oil and gas, mineral rights, and you have some disclosures that are required as part of that. Paragraph 5, earnest money termination option. This is where you put the stuff about the title company. So you've got to deliver to the title company if you're going to use, our firm has a relationship with Fidelity National Title at the time of this, and you put the address here of the title company. The dollar amount is the earnest money. Typically, you see 1% of the purchase price is earnest money. So if it's a $1 million property, your earnest money would be $10,000, and your option fee, you may see $500 or something like that as an option fee that goes there. Buyer shall additional earnest money. This typically isn't used, so you normally see NA or $0 here. And again, NA because the paragraph 5(1) typically is not used. You typically don't see an additional earnest money deposit. 5B, termination option. This relates back up to the option fee. So if you're paying a $500 option fee, you may see 10 days of the effective date of this contract. So the buyer would have the unilateral unrestricted right to terminate within 10 days in exchange for paying the $500 option fee. Title policy and survey in Texas, usually it's the seller that purchases the title policy for the benefit of the buyer. The policy is issued by one of the major underwriters in Texas. This is a common mistake you see by realtors is they'll put the title agent here. It's really the underwriter that goes here. So Fidelity, Old Republic, Stewart, you're not going to put something like Tradition or StarTex or whatever your local title agent is closest to the neighborhood. The name of the underwriter goes there. And then we get into some options about the policy. You can have the policy amended or deleted concerning shortages area at the expense of, usually this is some additional coverage for the buyer that relates to shortages in area, and you have to get a survey. Typically the buyer will pay for that, and it may be a couple $100. I usually recommend that buyers go ahead and get that. Survey, the seller may have a survey, in which case the seller will certify that survey with a T47 affidavit. That's okay. I like my buy. I don't love my sellers to make certifications about surveys. I generally think the less affidavits my clients are signing, the better. If I represent the buyer, I like the buyer to get a new survey, but I get that surveys cost money, and some people want to use the existing survey that the seller has. If you don't do that, then you can specify whether the buyer or the seller gets a new survey, or however that works. Paragraph D, objections. In residential properties, you usually see something generic here, like residential use, and then you may see something like 5 days there is pretty typical. And then we keep going until we get to the next blanks. I'm not going over the whole contract in detail because truly this is boilerplate. This contract is put out by the broker lawyer committee as part of TREC's service to the public. So it's a fairly unbiased contract. When our law firm represents buyers or sellers, we do some things to maybe favor it to one side or the other, depending who we're representing. On to property condition, paragraph 7. This is about the seller's disclosure, 7B. Normally, the seller's disclosure is uploaded in the back end of the MLS, and the buyer reviews it prior to making the offer, and you select buyer has received the seller's disclosure notice. And then continuing on as is, you usually put the buyer accepts the property as is. Some people get confused. That doesn't mean that the buyer can't have an inspection. The buyer can't later ask for repairs to be done, but normally you see buyer accepts the property as is. But don't take that to mean really much of anything. Residential service contracts. This is like a home warranty for the appliances in the house. So if you see a amount here, it's normally maybe $500 to $1,000, and that's a home warranty company. I'm not a real big fan of home warranty companies. I think if you get one and your dishwasher breaks, the seller normally pays for that. I don't think the home warranty company does a very good job of actually paying claims and replacing things, but that's just kind of my 2 cents. If you're the buyer and the seller's paying for it, then you might as well get it, I guess. Brokers and sales agents, this is a special disclosure. If there are any brokers or sales agents that are related to the transaction or they're a principal in the transaction, that disclosure needs to go here. That's part of a licensing act or a TREC rule requirement for our brokers and sales agents. So the broker lawyer committee added this in here to basically help sales agents out, and as a reminder for them to do that. Closing date, you put a closing date. If it's a finance transaction, you may see 30 to 45 days from the time of the contract is signed. Be careful not to accidentally select a holiday or a weekend, so check that. Possession, you usually see upon closing and funding, but for sellers, there may be some sellers out there that want to stay in the property after close and find a house, and the market may dictate that buyers would allow that or be amenable to that. So then you could put according to a temporary residential lease, which would allow the seller to stay there after closing. And there's an addendum for that. In some of TREC's other documents. Special provisions, you can include some special provisions here. Factual statements only if you're a realtor, and I noticed that the broker lawyer committee has made this much shorter because real estate agents and realtors were getting into trouble by going in there and really practicing law by writing some crazy things in there. So we've shortened this up to discourage realtors from doing any harm. But yeah, stick to factual statements here, or you can hire an attorney to do some drafting, in which case we would do it a completely separate addendum. We wouldn't actually use those 3 or 4 lines. But be careful to only put factual statements in there. If you're the principal in the transaction, feel free to have at it. You can butcher this thing up as much as you want. Settlement and other expenses, seller shall also pay. Sometimes you'll see a buyer that doesn't have much cash where the seller's kicking in some money to pay for closing expenses. So that may go there, especially in market buyer-friendly markets. You see that a lot. Continuing on, keeping things moving. Don't see any more blanks here, and as we continue to scroll. Notices, pretty standard stuff, where the buyer is going to receive notice, where the seller is going to receive notice. So be sure that's filled out for purposes of notices. Now we get to the addenda. These are the common addenda on the contract. I'll go through some of the major ones. Third-party financing addendum absolutely needs to be included. If you're using financing, it's not a cash transaction. Seller financing is if the seller is providing their own financing. HOA, mandatory membership in a property owners association. So if the property is subject to an HOA, that needs to be completed. Residential lease, that's if the buyer is doing a lease. We'll skip over some of these that aren't super common. The next common one, seller's temporary residential lease. We talked about that a little bit. That's a pretty common one if the seller is going to stay there a while. Lead-based paint is very common. If the property was built, I think it's 1978 or earlier, you need a lead-based paint addendum on there. And the other ones aren't super common. Consult an attorney. If any of the parties have an attorney, then we'll be listed here. So if we represent the seller or the buyer, you'll typically see the law firm. So in our case, maybe Silberman law firm goes there with the name of the specific attorney. And then this date is very, very important. It's executed the so-and-so day. This date triggers all the deadlines in the contract. So be sure that the last party to sign, so usually the buyer is the last party usually the seller is the last party to sign, because the buyer drafts the contract and then the buyer sends it to the seller to review, and then typically the seller might counter or do some type of invitation to resubmit another offer. But ultimately you get your final deal, seller signs. The effective date of that contract needs to be the date the seller signs and sends it back to the buyer. Don't let the seller put a different date there, because that date has critical consequences for the transaction. This is the broker information page. This is all about if there are realtors on the deal, license numbers. It says who they represent. The listing broker is typically the one that lists the house on the MLS. The other broker represents the buyer. The most common thing you'll see here is buyers only as buyer's agent and seller only as seller's agent. You've got the name and license information for all the brokers and their contact information. And then you'll have, you normally see 3% here in residential transactions. And I think a lot of people get confused. This is not a commission. This is not a binding commission agreement between the brokers. The commission is typically triggered or the obligations of the commission are implied within the MLS listing typically, where the posting of the property in the MLS constitutes an offer of commission. And then when the buyer brings the seller's broker, the buyer, and you have a contract, that's how the contract arises. This is more for informational purposes for the title company, and a lot of people get confused. And I think the broker lawyer committee, we clarified that. I say we, lawyers in the state, clarified this for realtors, saying that the disclosure is for information purposes only, because people were getting confused, and it was a little confusing to be honest. And then this is your receipt when you send this over to the title company, and now the title company is taking the option fee and the earnest money and the contract, putting that in escrow. This is the proof of receipt that they give back to the principals in the transaction or the realtors. So thanks for watching. That concludes our basic rundown of the TREC contract. If you have questions, let me know. If there are other topics you'd like to see, let me know. And don't forget to like and subscribe.